Appendix 1. How to prepare an anti-bullying policy. Trade unions. The policy should address the contribution to be made by the trade union/unions as appropriate, including as regards the prevention of bullying in the workplace through their participation in the development and implementation of policies and procedures, through their information and training services, and through the collective bargaining process. Trade unions may also play a role in providing information, advice, and representation to employees who have been bullied at work and to employees against whom allegations of bullying at work have been made. Employees. The policy should indicate that employees can contribute to achieving a work environment which does not tolerate bullying at work. This could also include cooperating with preventive measures introduced by management, and also through trade union strategies to eliminate or avoid bullying at work. Employees should recognize that if an investigator finds facts which evidence bullying at work, the matter may be dealt with through the disciplinary procedure. Equally, if the investigator finds facts which evidence a vexatious complaint, this may also be dealt with through the disciplinary procedure. Non-employees. The policy should indicate that bullying at work by non-employees such as clients, customers, and business contacts is not tolerated and may lead to termination of contracts or suspension of services, or to exclusion from a premises, or the imposition of other sanctions as appropriate. Communication of policy. The policy should include a commitment to effective communication of the policy. It should be communicated effectively to all those potentially affected by it, including management, employees, customers, clients, and other business contacts, such as those who supply and receive goods and services. Effective means of communicating a policy could include newsletters, training manuals, training courses, leaflets, websites, emails, toolbox, talks, and notice boards. Communication to employees. New employees, including those in management and all other positions of responsibility, should be made aware of the policy as part of any formal induction process to familiarize them with their job and their working environment and any rules and regulations that apply. Where a staff handbook is distributed to employees as part of the induction process, the anti-bullying policy should be included. Existing employees should receive updated and regular communication on the policy. Communication to non-employees. A summary of the anti-bullying policy should be prominently displayed where appropriate and as identified on the risk assessment, such as at places where members of the public, clients, and customers attended. Monitoring. The policy should include a commitment to monitoring and recording incidents of bullying at work. Statistics and information gathered from such monitoring should be recorded and used to assist the employer take corrective action or achieve continuous improvement in their bullying prevention policy and procedure. Training and supervision. Employees should be provided with such information, training, development, and supervision as is necessary to ensure the prevention of bullying. This should include making employees aware of the anti-bullying policy, information on the appropriate behavior to comply with the terms of the policy, training if needed in order to comply with the policy, and assistance if necessary to overcome a bullying incident, as well as adequate and informed supervision of the work environment. The policy should include commitments to staff training and supervision, as identified in the risk assessment on issues related to bullying at work, including the provision of training for managers, supervisors, and for all staff. At induction or through appropriate awareness-raising initiatives, such training should identify the factors which contribute to a working environment free of bullying and familiarize participants with their responsibilities under the policy and any problems they are likely to encounter. Such training is especially important for those members of staff responsible for supervision and for implementing the policy and responding to complaints. Best practice would ensure that records are kept by the employer of all such training. Reviews. The policy should include a commitment to review on a regular basis, in line with experience in the employment, changes in the law, relevant case law, or other developments. A responsible person should be named in the policy to ensure that monitoring, training, and reviews take place. Extracts from the Safety, Health, and Welfare at Work Act 2005, Section 8, General Duties of Employer. 8. 1. Every employer shall ensure, so far as is reasonably practicable, the safety, health, and welfare at work of his or her employees. 2. Without prejudice to the generality of subsection 1, the employer's duty extends in particular to the following: A. Managing and conducting work activities in such a way as to ensure, so far as is reasonably practicable, the safety, health, and welfare at work of his or her employees. B. Managing and conducting work activities in such a way as to prevent, so far as is reasonably practicable, any improper conduct or behavior likely to put the safety, health, or welfare at work of his or her employees at risk. C. As regards the place of work concerned, ensuring, so far as is reasonably practicable: 1. The design, provision, and maintenance of it in a condition that is safe and without risk to health. 2. The design, provision, and maintenance of safe means of access to and egress from it. And 3. The design, provision, and maintenance of plant and machinery or any other articles that are safe and without risk to health. D. Ensuring, so far as it is reasonably practicable, the safety and the prevention of risk to health at work of his or her employees relating to the use of any article or substance, or the exposure to noise, vibration, or ionizing or other radiations, or any other physical agent. E. Providing systems of work that are planned, organized, performed, maintained, and revised as appropriate so as to be, so far as is reasonably practicable, safe and without risk to health. F. Providing and maintaining facilities and arrangements for the welfare of his or her employees at work. G. Providing the information, instruction, training, and supervision necessary to ensure, so far as is reasonably practicable, the safety, health, and welfare at work of his or her employees. H. Determining and implementing the safety, health, and welfare measures necessary for the protection of the safety, health, and welfare of his or her employees when identifying hazards and carrying out a risk assessment under Section 19 or when preparing a safety statement under Section 20, and ensuring that the measures take account of changing circumstances and the general principles of prevention specified in Schedule 3. 1. Having regard to the general principles of prevention in Schedule 3, where risk cannot be eliminated or adequately controlled or in such circumstances as may be prescribed, providing and maintaining such suitable protective clothing and equipment as is necessary to ensure, so far as is reasonably practicable, the safety, health, and welfare at work of his or her employees. J. Preparing and revising as appropriate adequate plans and procedures to be followed and measures to be taken in the case of an emergency or serious and imminent danger. K. Reporting accidents and dangerous occurrences as may be prescribed to the authority or to a person prescribed under Section 33 as appropriate. And L. Obtaining where necessary the services of a competent person, whether under a contract of employment or otherwise, for the purpose of ensuring, so far as is reasonably practicable, the safety, health, and welfare at work of his or her employees. 3. Any duty imposed on an employer under the relevant statutory provisions in respect of any of his or her employees shall also apply in respect of the use by him or her of the services of a fixed-term employee or a temporary employee. 4. The duration of the assignment of any fixed-term employee or temporary employee working in his or her undertaking, it shall be the duty of every employer to ensure that working conditions are such as will protect the safety, health, and welfare at work of such an employee. 5. Every employer shall ensure that any measures taken by him or her relating to safety, health, and welfare at work do not involve financial cost to his or her employees. Section 9. Information for employees. 1. Without prejudice to the generality of Section 8, every employer shall, when providing information to his or her employees under that section on matters relating to their safety, health, and welfare at work, ensure that the information A. is given in a form, manner, and as appropriate language that is reasonably likely to be understood by the employees concerned, and B. includes the following information. 1. The hazards to safety, health, and welfare at work and the risks identified by the risk assessment. 2. The protective and preventive measures to be taken concerning safety, health, and welfare at work under the relevant statutory provisions in respect of the place of work and its specific task to be performed at the place of work. And 3. The names of persons designated under Section 11 and of safety representatives selected under Section 25, if any. 2. Where an employee of another undertaking is engaged in work activities in an employer's undertaking, that employer shall take measures to ensure that the employee's employer receives adequate information concerning the matters referred to in subsection 1. 3. Every employer shall ensure that employees appointed under Section 18 and safety representatives, if any, have access for the purposes of performing their functions relating to the safety, health, and welfare of employees. 2A. The risk assessment carried out under Section 19B information relating to accidents and dangerous occurrences required to be reported to the authority or person prescribed under Section 33 under the relevant statutory provisions. And C. Any information arising from protective and preventive measures taken under the relevant statutory provisions or provided by the authority, a person prescribed under Section 33 or a person referred to in Section 34. 2. 4A. Where an employer proposes to use the services of a fixed-term employee or a temporary employee, the employer shall, prior to commencement of employment, give information to the employee relating to 1. Any potential risk to the safety, health, and welfare of the employee at work. 2. Health surveillance. 3. Any special occupational qualifications or skills required in the place of work. And 4. Any increased specific risk which the work may involve. B. Where an employer proposes to use the services of a temporary employee, the employer shall 1. Specify to the temporary employment business concerned the occupational qualifications necessary for and the specific features of the work for which such an employee is required, and 2. Ensure that the temporary employment business gives the information referred to in paragraph A to the employee. 5. The temporary employment business referred to in subsection 4B shall give to the employee the information referred to in subsection 4B1. Appendix 2. Extracts from the Safety, Health, and Welfare at Work Act 2005 in Section 10. Instruction, Training, and Supervision of Employees. 10. 1. Without prejudice to the generality of Section 8, and having regard to Section 25 and 26, every employer shall, when providing instruction, training, and supervision to his or her employees in relation to their safety, health, and welfare at work, ensure that A. Instruction, training, and supervision is provided in a form, manner, and as appropriate language that is reasonably likely to be understood by the employee concerned. B. Employees receive during time off from their work, where appropriate and without loss of remuneration, adequate safety, health, and welfare training, including in particular information and instructions relating to the specific task to be performed by the employee and the measures to be taken in an emergency. C. In relation to any specific task assigned to an employee, that his or her capabilities in relation to safety, health, and welfare are taken into account, and D. In the case of 1. A class or classes of particularly sensitive employees to whom any of the relevant statutory provisions apply, or 2. Any employee or group of employees exposed to risks expressly provided for under the relevant statutory provisions, the employees concerned are protected against the dangers that specifically affect them. 2. Training under this section shall be adopted to take account of new or changed risk to safety, health, and welfare at work, and shall as appropriate be repeated periodically. 3. Training under this section shall be provided to employees: A. On recruitment, B. In the event of the transfer of an employee or change of task assigned to an employee, C. On the introduction of new work equipment, systems of work, or changes in existing work equipment or systems of work, and D. On the introduction of new technology. 4. Where in respect of any particular work, competency requirements are prescribed, the employer shall provide for the release of employees during working hours, where appropriate and without loss of remuneration, for the purpose of attending training in matters relating to safety, health, and welfare at work as regards the particular work. 5. Every employer shall ensure that persons at work in the place of work concerned who are employees of another employer receive instructions relating to any risks to their safety, health, and welfare in that place of work as necessary or appropriate. Appendix 2. Extracts from the Safety, Health, and Welfare at Work Act 2005. 6. Every employer who uses the services of a fixed-term employee or a temporary employee shall ensure that the employee receives the training appropriate to the work which he or she is required to carry out, having regard to his or her qualifications and experience. Section 13. Duties of employee. An employee shall, while at work, A. Comply with the relevant statutory provisions as appropriate and take reasonable care to protect his or her safety, health, and welfare, and the safety, health, and welfare of any other person who, not whom, may be affected by the employee's acts or omissions at work. B. Ensure that he or she is not under the influence of an intoxicant to the extent that he or she is in such a state as to endanger his or her own safety, health, or welfare at work or that of any other person. C. If reasonably required by his or her employer, submit to any appropriate, reasonable, and proportionate tests for intoxicants by or under the supervision of a registered medical practitioner who is a competent person as may be prescribed. D. Cooperate with his or her employer or any other person so far as is necessary to enable his or her employer or the other person to comply with the relevant statutory provisions as appropriate. E. Not engage in improper conduct or other behavior that is likely to endanger his or her own safety, health, and welfare at work or that of any other person. F. Attend such training and as appropriate undergo such assessment as may reasonably be required by his or her employer or as may be prescribed relating to safety, health, and welfare at work or relating to the work carried out by the employee. G. Having regard to his or her training and the instructions given by his or her employer, make correct use of any article or substance provided for use by the employee at work or for the protection of his or her safety, health, and welfare at work, including protective clothing or equipment. H. Report to his or her employer or to any other appropriate person as soon as practicable, 1. Any work being carried on or likely to be carried on in a manner which may endanger the safety, health, or welfare at work of the employee or that of any other person. 2. Any defect in the place of work, the systems of work, any article or substance which may endanger the safety, health, or welfare at work of the employee or that of any other person. Or Appendix 2. Extracts from the Safety, Health, and Welfare at Work Act 2005. 3. Any contravention of the relevant statutory provisions which may endanger the safety, health, and welfare at work of the employee or that of any other person of which he or she is aware, an employee shall not, on entering into a contract of employment, misrepresent himself or herself to an employer with regard to the level of training as may be prescribed under subsection 1F. Section 14. Interference, misuse, or risk. A person shall not intentionally, recklessly, or without reasonable cause A. Interfere with, misuse, or damage anything provided under the relevant statutory provisions or otherwise for securing the safety, health, and welfare of persons at work, or B. Place at risk the safety, health, or welfare of persons in connection with work activities. Section 19. Hazard Identification and Risk Assessment. 19. 1. Every employer shall identify the hazards in the place of work under his or her control, assess the risks presented by those hazards, and be in possession of a written assessment to be known and referred to in this act as a risk assessment of the risk to the safety, health, and welfare at work of his or her employees, including the safety, health, and welfare of any single employee or group or groups of employees who may be exposed to any unusual or other risk under the relevant statutory provisions. 2. For the purpose of carrying out a risk assessment under subsection 1, the employer shall taking account of the risk or of not the risk of the work being carried on at the place of work, have regard to the duties imposed by the relevant statutory provisions. 3. The risk assessment shall be reviewed by the employer where A. There has been a significant change in the matters to which it relates, or B. There is another reason to believe that it is no longer valid, and following the review, the employer shall amend the risk assessment as appropriate. 4. In relation to the most recent risk assessment carried out by an employer, he or she shall take steps to implement any improvement considered necessary relating to the safety, health, and welfare at work of employees and to ensure that any such improvement is implemented in respect of all activities and levels of the place of work. 5. Every person to whom sections 12 or 15 applies shall carry out a risk assessment in accordance with this section to the extent that his or her duties under those sections may apply to persons other than his or her employees. Appendix 2 extracts from the Safety, Health, and Welfare at Work Act 2005, Section 20, Safety Statement. 20. 1. Every employer shall prepare or ask to be prepared a written statement to be known and referred to in this act as a safety statement, based on the identification of the hazards and the risk assessment carried out under Section 19, specifying the manner in which the safety, health, and welfare at work of his or her employees shall be secured and managed. 2. Without prejudice to the generality of subsection 1, every employer shall ensure that the safety statement specifies A. the hazards identified and the risks assessed, B. the protective and preventive measures taken and the resources provided for protecting safety, health, and welfare at the place of work to which the safety statement relates, C. the plans and procedures to be followed and the measures to be taken in the event of an emergency or serious and imminent danger in compliance with sections 8 and 11, D. the duties of his or her employees regarding safety, health, and welfare at work, including cooperation with the employer and any persons who have responsibility under the relevant statutory provisions in matters relating to safety, health, and welfare at work. E. the names and, where applicable, the job title or position held of each person responsible for performing tasks assigned to him or her pursuant to the safety statement. And F. the arrangements made regarding the appointment of safety representatives and consultation with and participation by employees and safety representatives in compliance with sections 25 and 26, including the names of the safety representative and the members of the safety committee, if appointed. 3. Every employer shall bring the safety statement in a form, manner, and its appropriate language that is reasonably likely to be understood to the attention of A. his or her employees at least annually and at any other time following its amendment in accordance with this section. B. Newly recruited employees upon commencement of employment, and C. or another B, another persons at the place of work who may be exposed to any specific risk to which the safety statement applies. 4. Where there are specific tasks being performed at the place of work that pose a serious risk to safety, health, or welfare, an employer shall bring to the attention of those affected by that risk relevant extracts of the safety statement setting out A. the risk identified, B. the risk assessment, and C. the protective and preventive measures taken in accordance with the relevant statutory provisions in relation to that risk. 5. Every employer shall, taking into account the risk assessment carried out under Section 19, review the safety statement where A. there has been a significant change in the matters to which it refers, B. there is another reason to believe that the safety statement is no longer valid, or C. an inspector, in the course of an inspection, investigation, examination, inquiry under Section 64 or otherwise directs that the safety statement be amended within 30 days of the giving of that direction, and following the review, the employer shall amend the safety statement as appropriate to cooperate. 6. Every employer who is conducting activities as may be prescribed in accordance with this subsection, who contracts with another employer for that employer to provide services to him or her, shall require that the employer is in possession of an up-to-date safety statement as required under this section. 7. A copy of safety statement or relevant extract of it shall be kept available for inspection at or near every place of work to which it relates while work is being carried out there. 8. It shall be sufficient compliance with this section by an employer employing 3 or less employees to observe the terms of a code of practice, if any relating to safety statements, which applies to the class of employment covering the type of work activity carried on by the employer. 9. Every person to whom Section 12 or 15 applies shall prepare a safety statement in accordance with this section to the extent that his or her duties under those sections may apply to persons other than his or her employees. Section 60. Codes of Practice. 60. 1. For the purpose of providing practical guidance to employers, employees, and any other persons to whom this act applies with respect to safety, health, and welfare at work, or the requirements or prohibitions of any of the relevant statutory provisions, the authority A. may and shall, if so requested by the Minister, prepare and publish codes of practice, and B. may approve of a code of practice or any part of a code of practice made or published by any other body. 2. Before publishing or approving of a code of practice or any part of a code of practice under this section, the authority A. shall obtain the consent of the Minister. B. may publish in such manner as the authority considers appropriate a draft of the code of practice or sections of a draft code of practice, and shall give persons 1 month from the date of publication of the draft code or sections within which to make written representations to the authority in relation to the draft code or sections of the draft code or such further period not exceeding 28 days as the authority in its absolute discretion thinks fit. And C, following consultation and where relevant, having considered the representations, if any, shall submit the draft code to the minister for his or her consent to its publication or approval under this section with or without modification. 3, where the authority publishes or approves of a code of practice or approves of any part of a code of practice, it should publish a notice of such publication or approval in Iris Oifigil, and that notice shall A, identify the code, B, specify the matters relating to safety, health, and welfare at work, or the relevant statutory provisions in respect of which the code is published or approved of, and C, specify the date on which the code shall come into operation. 4, the authority may be with the consent of the minister and following consultation with any other person or body that the authority considers appropriate or as the minister directs. A, amend or revoke any code of practice or part of any code of practice prepared and published by it under this section, or B, withdraw its approval of any code of practice or part of any code of practice approved by it under this section. 5, where the authority amends or revokes or withdraws its approval of a code of practice or any part of a code of practice published or approved under this section, it shall publish notice of the amendment, revocation, or withdrawal as the case may be. In Iris Oifigil, the spelling IRISOIFIGIUIL. 6, the authority shall make available for public inspection without charge at its principal office during normal working hours A, a copy of each code of practice published or approved by it, and B, where a code of practice has been amended, a copy of the code as so amended. 7, notwithstanding the repeal of the Act of 1989 by Section 4, a code of practice in operation immediately before the commencement of that section continues to be a code of practice as if prepared and published under this section. Section 61. Use of codes of practice in criminal proceedings. 61. 1. Wherein proceedings for an offense under this act relating to an alleged contravention of any requirement or prohibition imposed by or under a relevant statutory provision, being a provision for which a code of practice had been published or approved by the authority under Section 60 at the time of the alleged contravention, subsection 2 shall have effect with respect to that code of practice in relation to those proceedings. 2. A. Where a code of practice referred to in subsection 1 appears to the court to give practical guidance as to the observance of the requirement or prohibition alleged to have been contravened, the code of practice shall be admissible in evidence. B. Where it is proved that any act or omission of the defendant alleged to constitute the contravention, 1. is a failure to observe a code of practice referred to in subsection 1, or 2. is a compliance with that code of practice, then such a failure or compliance is admissible in evidence. 3. A document bearing the seal of the authority and purporting to be a code of practice or part of code of practice published or approved of by the authority under this section shall be admissible as evidence in any proceedings under this Act, Safety, Health, and Welfare at Work Act 2005, Number 10 of 2005. Section 8. General Principles of Prevention. 1. The avoidance of risks. 2. The evaluation of unavoidable risks. 3. The combating of risks at source. 4. The adaptation of work to the individual, especially as regards the design of places of work, the choice of work equipment, and the choice of systems of work, with a view in particular to alleviating monotonous work and work at a predetermined work rate, and to reducing the effect of this work on health. 5. The adaptation of the place of work to technical progress. 6. The replacement of dangerous articles, substances, or systems of work by safe or less dangerous articles, substances, or systems at work. 7. The giving of priority to collective protective measures over individual protective measures. 8. The development of an adequate prevention policy in relation to safety, health, and welfare at work, which takes account of technology, organization of work, working conditions, social factors, and the influence of factors related to the working environment. 9. The giving of appropriate training and instructions to employees. Health and Safety Authority, www.hsa.ie. Guidance on risk assessment and safety statements, Workplace Safety and Health Management, Workplace Relations Commission, www.workplacerelations.ie, Procedures for Addressing Bullying in the Workplace, Grievance and Disciplinary Procedures, Voluntary Dispute Resolution, SI 76 of 2004, Irish Human Rights of Equality Commission, IHRC, www.ihrec.ie. Code of Practice on Sexual Harassment and Harassment at Work, Department of Enterprise, Trade and Employment, Bullying in the Workplace Survey Reports 2007, website, enterprise.gov.ie, and publications, /Bullying in the Workplace Survey Reports, -2007.html.